Hello, everyone, and welcome to our NAIA webinar regarding the 2018 Title IX changes. My name is Dr. Justin Lawrence. I'm the Title IX Administrator at Wayland Baptist University, and so I want to talk to you about the upcoming changes that we're going to see with regard to Title IX and how that would affect you in your role at your university and affect your particular athletic department and Title IX department. So let's go ahead and get started. One of the first changes that you're going to see is in regard to jurisdiction. So the definition of sexual assault that schools must adjudicate will be narrowed down only to include incidents that happen on campus. And so colleges would be responsible for handling allegations of sexual misconduct that occurs on their campuses and in their institutional programs, but not in settings like off-campus student apartments or at off-campus parties. And so currently campuses are required to investigate conduct regardless of where it happened, but now schools will no longer be liable and no longer have an obligation to investigate incidents that happen off-campus. So if it's off-campus housing, an off-campus apartment, or even if it's an off-campus party. And so this is something that we need to pay a lot of attention to in educating our students and student athletes. One of the next areas that we're going to see changes is in complaints. Schools will only be held accountable for formal complaints that are filed through the proper authorities. Now, the proper authorities is the big issue here. So colleges will be held accountable only for responding to formal misconduct complaints filed through official institutional channels or allegations of which officials have actual knowledge. And so these individuals would be the Title IX administrator or the dean of students, someone who's trained in the area of Title IX, but it wouldn't be a professor, it wouldn't be an RA, it wouldn't be a coach. And so we have to find out who those proper authorities are going to be. Otherwise, a student could cry out to someone on campus about something happening to them, and it would not be considered a formal complaint. Again, a formal complaint would be one made to an official who has the authority to institute corrective measures. So again, that's going to be your Title IX coordinator or maybe your deputy Title IX coordinator if you have that. But it's not going to be a one-size-fits-all anymore where somebody can cry out to a faculty member or cry out to a coach or a graduate assistant or an RA. That's going to be completely different. And so this standard is going to be different from the one dating back to 2001 when schools were held accountable if it knew or reasonably should have known about the possible harassment. So this is going to be another big change that's coming ahead of us. The regulation will also define the complainant as the individual who reported being the victim of the conduct that could constitute sexual harassment or on whose behalf the Title IX coordinator has filed a formal complaint. So this means that a non-victim could not force the institution to initiate grievance procedures by filing a formal complaint of conduct that was targeted at somebody else. So what this means is now if a witness or a friend that the person talked to or spoke out to, if they came and filed the complaint, it would not be considered a formal complaint, and now that person would not be the complainant. So you really wouldn't be able to do an investigation or undertake one because you're not formally put on notice. You don't have a formal complaint, and non-victims are really going to be taken out of the equation here. So that's another area, because as a Title IX administrator, I can tell you that many times we get claims that come directly from the complainant, but oftentimes we get claims that and investigations that begin from a witness that was there or somebody who the complainant confided in or who the respondent confided in. So that's where we get claims from as well. So that's going to be another change that's coming down the pike. For an example of this, when you look at sexual harassment, which was reported to a professor or a coach or an RA, this is not going to be covered under the new rules because it would have had to have been reported to an investigator or a school official such as a Title IX administrator or Title IX coordinator or deputy Title IX coordinator. Furthermore, if the conduct occurred off campus, then the school does not need to conduct an investigation. It is not even their responsibility to address the complaint. So if something happens off campus, then there's really not going to be a complaint. There's really not going to be any liability for the school in that area. Legally, institutions are only going to be responsible for investigating complaints that they have knowledge of happening. And so if the school is unaware of a complaint because it hasn't been formally filed, then they're not going to be legally responsible for addressing it. So if something happens off campus and somebody comes and talks about it 6 months later, the school is not going to be liable for having to undertake a Title IX investigation or be liable to be sued under that. Currently, schools would be liable because they knew or should have known, or at least they would, at the very minimum, they would have a duty to investigate that claim. One of the other changes that's going to come through is evidentiary standards. So supportive measures will be defined as non-disciplinary individual services offered as appropriate to the complainant or the respondent after the filing of, again, here's this word, formal complaint, or where no formal complaint has been filed. So this means no contact orders. This is if you have to separate students from being in contact with each other, or if you have to remove them from classes, some kind of way where they need to be separated and not be around each other while the investigation is going on. These measures now can be non-punitive and time limited, and they have to be narrowly tailored to support continued access to an education program or activity without unreasonably burdening the other party. So this is going to change how we institute interim measures during an investigation. So this is going to it really beefs up the rights for our students and student athletes, but we need to be aware of how we're going to institute supportive measures. These aren't corrective measures. These are just supportive measures that help to stop any harm from happening or to stop the activity from happening that was alleged and be able to move through the investigation to have a finding. Campuses will now have the option to raise the burden. So as we look at these evidentiary standards, campuses now have the option to raise the burden of proof from a preponderance of evidence, which is 50% plus a feather, to a standard of clear and convincing, which is around 75%. And so now schools are going to have the option. Typically, schools are going to be at preponderance of evidence, or they're going to be where they're going to have to match their student conduct. So if your student conduct has preponderance of evidence, then Title IX will need to have preponderance of evidence. But if the student conduct has clear and convincing and Title IX was preponderance of evidence, then Title IX can now move up to clear and convincing. But again, an institution may use preponderance of evidence only if it uses that standard for all other discriminatory harassment complaints. So what this means is we can't have different levels of evidence that we're using for student conduct violations or employment conduct violations or Title IX violations. They've all got to be on the same page. So everything now has to line up with the evidentiary standards. As far as appeals, schools can decide whether or not they want to allow an appeals process. And so the new regulations will specify that an institution, that if they allow an appeal, it may allow an appeal either solely by the respondent or by both parties. But if allowed for both parties, then the appeal procedures must be equally available. So if you allow both parties to do it, then the procedures, this is going to get into policy. So you got to make sure that you've evaluated your Title IX policies or sexual misconduct policies at the school, because now the appeal procedures come in and they have to be equally available, and both the respondent and the complainant have to have equal rights, equal access in this appeals process. But one of the big things here is now you're not mandated to have something for both parties, both the complainant or respondent to appeal. You can choose who you want to allow appeal or if you want to allow an appeal. One of the next things that's going to change is mediation. Schools can use mediation to reach informal resolutions. Currently, no form of mediation is deemed appropriate for sexual misconduct cases, and this is due to the power dynamics between the victim and the accused. However, the new regulations that will come in place would explicitly address informal resolution and permit it at any time prior to reaching the determination of responsibility. So at any time during the investigation, mediation could be triggered without having to determine a finding of responsibility or non-responsibility. And so informal resolution may include mediation, but it can only be used with the party's consent after there's written notice disclosing the following. So the allegations have to be disclosed, the requirements of the informal resolution process. Again, this is policy. So if you don't have a mediation policy in your Title IX sexual misconduct handbook or sexual misconduct policy, now this is going to have to be written in. So we've got to pay a lot of attention to our policies here. So the informal resolution process, including the circumstances under which party can result in a formal complaint. The other thing is any consequences for participating in an informal resolution, including records that may be maintained or shared. All of this has to be covered. And so this is going to be a policy discussion. And so I would think that a lot of schools are going to have to update their sexual misconduct policies and procedures to reflect this. So change will be coming in this area as well. One of the other areas that's going to affect our policies and how we conduct and procedures is cross-examination. The complainant and the accused can request evidence from each other and cross-examine each other. Additionally, both sides can have access to evidence obtained during the investigation, even if the evidence isn't used. So there's not going to be any more element of surprise or having bits and pieces of evidence that are released to the complainant and respondent and pieces of evidence that aren't. Anything that you have access to will need to be turned over to both sides in this process. And one of the things about cross-examination is currently any allowance of each side to question the other side is currently deemed to intimidate the victim and to perpetuate a hostile environment. But now students will be allowed to cross-examine one another. They will currently not allowed to be in the same room, but they will be allowed to utilize advisors and ask questions to each other in this process of determining responsibility or non-responsibility in Title IX cases. One of the other changes that's going to be coming is the sexual harassment definition. So the definition of sexual harassment applies to repeated complaints and egregious allegations. And so one of the things that you need to understand about this is that the current definition is going to be broader. It's going to include unwelcome conduct of a sexual nature. So the current definition we have to understand is much broader than where we're going with the changes. And so currently we have the unwelcome conduct of a sexual nature, including unwelcome sexual advances, requests for sexual favors, and other verbal and nonverbal and physical conduct of a sexual nature. The new changes are going to beef this up to a constitutional level. We're going to have the constitutional level of sexual harassment now, and the constitutional definition, which applies to repeated complaints of egregious allegations. So the new rules of the Education Department will change the definition of sexual harassment to the unwelcome conduct on the basis of sex that is so severe and pervasive and objectively offensive that it denies access to the school's education program or activity. And so one of the things that I want you to understand about this is you look at this definition. So it's going to be unwelcome conduct on the basis of sex. That's one prong that's going to have to be proved. The next thing that we're going to have to see is it's going to have to be severe and pervasive. The next thing after you pass the severe and pervasive prong is this is not an and or, it's an and. Then it's going to have to be objectively offensive. So not just offensive to that person, but it would need to be offensive to other people. And then it would have to deny a person access to the school's education program or activity. So the standard is going up. The proposed new definition will create a much higher standard for what is categorized as sexual harassment. And although the new rules don't define hostile environment, they do allow campuses to remove an accused person if they are determined to be a safety risk. So if the person is a safety risk, if they could offend or harm someone else or do something to somebody else, they can be removed from the campus at that point. The regulation defines actual knowledge as occurring when an official or a recipient who has authority to institute corrective measures has a notice of this. So here we go again with the formal notice and really having a formal complaint. And so you only have actual knowledge when the Title IX coordinator or the Title IX administrator, the person who can actually do something about this sexual harassment or sexual harassment allegation, that's the only time that we're going to have formal notice. And so this is going to be the Title IX coordinator, Title IX administrator, but it's not going to be faculty. It's not going to be an RA. We're not for sure whether this is going to include coaches or athletic directors. I doubt it's going to include coaches. Maybe the AD could be in that conversation if they are a deputy Title IX coordinator, but it's really going to be someone who can do corrective action, whoever that person is on your campus. And so what this really does is now it shrinks the pool of people who are going to be mandatory reporters for Title IX. One of the other changes that's coming is the FERPA preemption. Right now, FERPA and Title IX are in deep conflict. And so there may be a situation where you need to contact a student athlete's parents or a family member. Maybe there's a domestic violence situation. Maybe there's been an assault. And right now, if the student athlete does not want their parents to know about this, then you're at a crossroads. Now, FERPA does have a health and safety exception that could come in, but now the regulation is going to ease that and say that if Title IX and FERPA are in conflict, Title IX will override FERPA to the extent that there's a conflict. So now Title IX is going to take precedent over FERPA, which is going to be of great assistance in Title IX investigations where you see them conflicting and what information can you release to whom. Title IX will take precedent there. One of the other things that's going on with investigations, this is not a big change, but investigations should be impartial, as they are currently, and resolutions should be prompt and equitable. Additionally, a campus's unfair or inadequate treatment of the accused, and not just the victim, could constitute sex discrimination. So this is a change right now. It used to be it was just if it was unfair or inadequate treatment of the victim, then lawsuits would come. But now, if there's inadequate treatment of the accused, that could constitute sex discrimination as well. And we're seeing a lot of lawsuits now that are coming from respondents who were accused of sexual misconduct on their campuses, that they weren't afforded their rights, and now they are suing. And so we're seeing a big rise of that. And so one of the other things that's going to happen with these changes is Title IX is already heavily litigated, but I believe it's going to be even more heavily litigated now with the changes. So we have to make sure that not only our complainants and victims, but also the accused and respondents know their rights. Students are going to have to know their rights. They're going to have to really have a firm understanding of Title IX and the procedures and the policies. And if they don't, then we could put the schools at liability. And so we have to put a premium on educating not only our student athletes, but now we've got to educate anybody that's going to be involved in this area. Got to make sure we educate the coaches. We've got to make sure we educate the athletic directors, because one misstep could put the school, expose the school to tremendous liability. One of the other things that we see here is that the accused should be presumed innocent until proven guilty. And Title IX has been criticized, some schools' policies and procedures on how they handle it, because sometimes the accused are not presumed innocent until proven guilty. They should, but sometimes they're presumed guilty until proven innocent, which is why we see a lot of the lawsuits. So you got to make sure that every investigation is fair and impartial. That is critical. So that means that whomever is doing the adjudication and investigation of Title IX claims cannot be biased. They have to be fair. They have to be impartial. They have to be objective. And that's why you're going to want to have multiple people conducting these investigations. You don't need to have the same person. You need to find out what's going on your campus. You know, the students need to understand that if there's one person that's conducting an investigation and they're adjudicating that as well, that means they're doing the finding and find out whether this person is going to be responsible or not responsible. That's going to be an issue going forward, because that's not fair or impartial. So all of these are going to change. The single investigator model is going away. And so we need to make sure that we understand our policies and procedures and how we can best protect our student athletes, educate them. One of the other things that we're going to see is retaliation. The new regulation would make it clear that it is not retaliation for a school to take disciplinary action against a person who makes a bad faith complaint or who knowingly provides false information during an investigation or adjudication. So this is not retaliation. So before, it could have been considered retaliation, but if a person makes a bad faith complaint or if they provide false information during the investigation or adjudication, because this could swing how the case comes out. This could swing how the findings come out, now if action is taken against a student or whomever reported, or a witness, whomever, or a complainant who makes a bad faith complaint or just provides false information, that's not going to be retaliation if the school takes disciplinary action against them. Now, one of the things I want to tell you is that we have an underreporting issue, but we do not have a false reporting issue at this time. The biggest issue that we have is underreporting. One of the other things that we're going to see is with evidence, in the area of evidence. And so investigations should result in a written report summarizing all of the relevant exculpatory information and inculpatory information. So that means any information that could lead to the respondent being responsible for this, or for the respondent being not responsible, then there's going to have to be a written report that summarizes all of that evidence. The regulations appear to contain similar language that will require the school to share this information. And so again, this policy changes night and day. And the question is going to be, will colleges comply with the spirit of the regulation, which we're not sure. But once an accused student's lawsuit gets to court, the university would need to explain why it ignored a federal mandate for fairness. And so we have to make sure that our student athletes know what's afforded to them. But our coaches and athletic directors and Title IX coordinators are going to really have to understand this in our level in the NAIA, because NCAA schools are getting sued left and right. See lawsuits every day. And we're not seeing that in the NAIA, and we don't want to see that in the AA. So that's why we're going to continue educating so that we know what we're doing and we know what's changing and how to adjust to it. One of the other things that we're going to see is the outcome determination. So the new regulation will require the school to issue a written determination of the outcome of a formal complaint that includes the following. So now the outcome determination is going to be a report, and it's going to have to show the sections of the policy that were violated, a description of the procedural steps taken from the receipt of the complaint through the determination. So this means that if someone, either the complainant who complained about sexual misconduct or the respondent who was accused of sexual misconduct, what this means is that each of them are going to get a report that's going to state the sections of the policy violation. Then they're going to get a description of when did this case come in, how was it handled, what was done after the case came in, who was interviewed, how did you decide who you're going to interview, what did you find out when you interviewed the witnesses and the complainant and the respondent, what evidence was obtained. You're going to have to look at all that. How did you arrive at your determination? You're going to have to have findings of fact that support your determination. So what facts actually determine that this person violated policy? And then you're going to have conclusions regarding the applications of the facts to the policy language. So you've got to understand the facts of the complaint, and you're going to have to get those facts and you're going to have to apply them to your policy to come up with a decision. And so what they're asking for is a statement of rationale for each allegation, including the determination regarding responsibility or non-responsibility or any sanctions and any remedies provided. So it's going to have to be very specific. We want to make sure that our student athletes are getting this, both complainants and respondents. And so this is it's going to be a lot of work. It's a pretty big report, but we need to make sure that they're getting it. We need to make sure that our complainants are getting this and that our respondents are getting this, or otherwise this could turn into, it could expose the university to a lawsuit. And so this outcome determination is a huge change. One of the other things is training. So the interim guidance in 2017 required that training avoid sex stereotypes. And we believe that this is going to stick in the new regulations. And so the proposed regulations are also going to require training about the campus policies. So it's going to have training about the regulations and the campus policies. And they're going to order schools to divulge the contents of the training to any accused student that asks for them. So if someone gets accused of sexual misconduct, you have a student athlete that gets accused of stalking or sexual harassment, or sexual assault or domestic violence. So if they get accused of any of that and they say, hey, they talk to the Title IX administrator and say, hey, I need to get a copy of all the training that you provided. The school is going to have to turn over any of that training. And if any of that training had sexual stereotypes that that made fun of rape victims or called, all perpetrators of rape, if they said these kinds of people always commit rapes or something like that, any kind of sexual stereotype, anything that's unfair, anything that seems biased, that's going to get the school in trouble. And so this provision is the most significant of any of the regulations, in my opinion, and because training materials have been notoriously one-sided. And so there can't be any more one-sided training. It's going to have to be balanced, and we're really going to have to pay attention to what we're doing in training student athletes, and probably going to have to get away from a lot of the video training and really start creating in-house training at your schools. And so we have to make sure that we have fair training materials and that the contents are not one-sided, because that will be used in a lawsuit. So now any training that we're doing, got to make sure that it's balanced. So this is a big change. And so if you have any questions about these regulations, one thing I want to tell you, we're in the 60-day comment period, and that was released on November. These regulations were released for a comment period November 28th, 2018. So January 28th, 2018, the comment period will be over, and then the regulations will begin to stick at any time after that. And so you're going to hear a lot more about this coming into the new year, especially at the beginning of February. And so now is the time to really be thinking and talking to your Title IX coordinators, deputy Title IX coordinators, presidents, athletic directors, everybody getting together and really getting a handle on how training is going to be handled, how policies are going to be handled, how procedures are going to be handled. Need to really start revisiting this, because I strongly believe that we're going to have an overhaul in a lot of the things that we're doing, because what we've been doing doesn't necessarily match what's coming. So if you have any questions about this, don't hesitate to reach out. My email is Lawrence, J, L-A-W, R-E-N-C-E-J @wbu.edu. Again, that's Lawrence, J, L-A-W, R-E-N-C-E-J @wbu.edu. Also, I'll give you my cell phone number. It is 806-535-5907. Don't hesitate to reach out with any questions that you have. We're here to help you on behalf of the NAIA. We're not telling you what to do. That's not our job. We're not telling you how to run your Title IX, not telling you how to develop your policy or draft your policy. We're just here as a resource so that you can get feedback on the guidance that's coming, on the rules and regulations that's coming, and also find out best practices. So we're just here to come alongside you to help you to take care of your campus and your student athletes and make sure that they have the best experience possible at our NAIA member schools. So I want to thank you for your time. Look forward to hearing from you. If you have any questions, don't hesitate to reach out. Thank you.